May it please the court, Keith Upson for the appellant father. I'd like to reserve all 5 minutes, if I may. The hearing at issue was on the mother's motion to dismiss for lack of jurisdiction that specifically challenged that the 6-month residency requirement had not been met. That was what brought the father before the court at the hearing at issue. It was on the mother's motion to dismiss on the very narrow ground of not having been in the jurisdiction for the 6 months prior to the initiation of the paternity action. It's important to note at the outset that the motion at issue did not allege any emergency. It claimed no emergency. It contained no allegations or grounds that could constitute an emergency. Procedural due process requires fair notice on the grounds upon which relief is sought by requiring that the basis for the motion be expressly articulated with sufficient particularity to put the opposing party on notice of the grounds that are going to be asserted at the hearing. That's from Empire World Towers, cited in our briefs. More recently, this court in Ferris versus Wynn, and Judge Silberman, while you didn't author the Ferris decision, I'm sure you'll appreciate me pointing out that you were on the panel.
Thank you, Mr. Judge.
And I believe that was early 2018.
At the beginning of the oral argument session, is that?
I've been here all day, Judge. But I know the court always appreciates when I bring those facts to their attention anyway, because if your memory is anything at all like mine, it may very well be that you were on the panel a year ago, but if it's not in front of you at the moment, it may not be at the front of your mind. I get a little pickier about it when members of the panel actually wrote the decision, because then I think at least some part in preparation should stick or be retained. But in 2018, the Ferris panel said procedural due process is comprised of both fair notice and a real opportunity to be heard. The notice must be of such nature as reasonable to convey the required information, must afford a reasonable time for those interested to make their appearance, while the opportunity to be heard must be at a meaningful time in a meaningful manner. Now here, as in Ferris, no emergency situation was expressed in the motion or otherwise existed that would have allowed the father's procedural due process rights to give way. So absent an emergency, procedural due process required the father receive fair notice of the specific grounds, fair notice of the particular grounds upon which the mother was seeking relief. At hearing, the ground upon which the mother sought relief was unjustifiable conduct pursuant to 61-521. Now that's similar in some ways to an affirmative defense in that it requires first the mother acknowledge that the 6-month jurisdictional requirement had in fact been met, something that is expressly contrary to what the mother had consistently asserted was not true. And accordingly, the only notice father ever received was that the hearing would challenge whether or not they'd met the 6-month residency requirement. So why did he expect the hearing to be on whether or not they'd been in Florida for 6 months? Well, because every single thing she had ever filed stated that basis and that basis alone as being the particular grounds upon which the court should not exercise jurisdiction.
But if you have this solid case, I assume the husband thought, and the law provides for some exception to that solid case. I mean, in all instances in which at a hearing, opposing party brings up some exception that exists in statute or case law, the due process requires a new hearing, so that the party who thought he had a solid case could parry that exception that existed in the law.
Well, and I'm not clear, the first word you were using, Judge, was it solid case, or are you referring to a citation?
No, I'm saying what it sounds to me is like the husband thought he had a solid case because the day after the 6-month ran, filed his complaint or petition. And in every scenario in which a party goes to hearing thinking they have a solid case, but yet there was some exception to that solid case in case law or whatever, that because the respondent had not heretofore raised that prior to the hearing, that's a due process violation?
It's absolutely a due process violation, Judge, because they held a hearing on a ground that was contradictory with the ground that had been asserted for the basis of the motion to dismiss throughout.
If it's a due process violation, then how do we contemplate things such as trial by consent or amendments to conform to the evidence, which we do in civil cases not infrequently?
Judge, there's not any, this court has everything it needs in the record to conclusively determine that he did not receive any notice that anyone at all at this evidentiary hearing was going to say 61-521. And what we do have immediately subsequent are the extensive motions for rehearing that repeat a lot of the same argument, presumably, that was made at the time of the hearing.
I can't presume that because I don't know what was made at the hearing because I don't have a transcript of the hearing.
But we don't need it. We really don't need it. And to get back briefly, Judge Atkinson, to your question, because you were talking about an exception. The basis for the statutory basis upon which the court refused to exercise jurisdiction, it's not a loophole in due process, nor is it a loophole in the 6-month residency requirement. It's an entirely different legal theory. Legal theory. I anticipate an argument, much like the answer brief, counsel's going to talk about facts. Doesn't matter. It doesn't matter. Where a hearing is held on a legal issue that literally came out of nowhere, it is a due process denial.
But that's just not correct. I mean, it can be, but you're saying that as a categorical rule, and that's just not correct. I mean, again, the rules allow issues to be tried by consent or defenses to be waived. We allow some bandwidth for that, so that in the interest of finality at hearings. So I'm just not sure how we get around that.
Well,
I mean, if you can put it this way, if you can have an entire trial on an issue that no one pled, but it gets tried by consent, and that is okay as far as civil procedure goes, and there is no constitutional violation, I'm not sure how we say a motion to dismiss is categorically distinct from that.
Well, Judge, and I appreciate, due to the nature of the roles and the relationship in the courtroom, I can't ask the court for authority that would effectively eviscerate the authority relied upon in our briefs, that categorically, and I appreciate I'm contradicting your position, but Vaught, Williams, Ferris, all substantially similar in a number of ways, and all categorically on the record we have available, there is enough here for this court to look at that and say, yeah, you know what, blindsided? Blindsided means blindsided. That's a denial
of a transcript. Normally what we have to look at is the face of the final judgment and determine if there is a defect on the face of the final judgment that renders it reversible. What is happening here is clearly the motion or the petition that was filed to get into court by the mom doesn't say anything about unjustified conduct. But what we don't know is at the beginning of the trial whether the argument was made by mom, whether dad asked for a continuance saying, surprise, I don't know what that's about, I'm not ready for it, or dad says there is no unjustified conduct, the evidence is going to prove that we acted reasonably under all circumstances, and then the case goes to trial. And we don't know that. And so how do we square what I first said, that we have to look at the face of the judgment to determine if there is anything irregular on its face, versus the whole issue of lack of a transcript, presumption of correctness, potential that there was a waiver or a potential that it was tried by consent.
Well, which, Judge, is why I spent a considerable amount of time and energy addressing, parsing line by line, the facts, the findings of the court in its order, that there is no factual even if everything the judge relied upon, even if all that's true, it doesn't constitute a legal basis to
Assuming
exercise.
for the purpose of my question, that we think the findings are sufficient for the unjustifiable conduct. So the real question is, can you get relief because of a due process violation based on what otherwise appears to be a regular final judgment?
Absolutely, Judge, and you need to look.
Is there any authority, because the cases that you cite don't involve lack of the transcript where there is no irregularity on the face of the judgment?
Well, and again, I'm not conceding that there's no irregularity on the face of the judgment. I appreciate your position that for our purposes, and I wasn't going to stand and devote time to arguing the facts or the findings. You know, I'm going to rely on the briefs for that regardless. But the father's uncontested motions for rehearing and motions to recuse contain several, both can't be true.
Well, the first thing the father says in the motion for rehearing in paragraph 7 is the court cited unjustifiable conduct but has failed to say what was unjustified. Just because one files at the 6-month mark or consults with an attorney does not make their conduct unjustified. So that's the first thing that he says. He doesn't say, so I was surprised, this was never tried by consent, I don't know where the court came up with this. Granted, later in the motion,
He does say those things, Judge.
But, you know, the father seems to be taking the dual position that, okay, you've ruled on unjustified conduct, Judge, you're wrong, you ought to reconsider that.
Well, but Judge, if you recall, the court also issued 2 orders. It's very short, you lose, you win, the end, that's it. That did contain absolutely no findings. And I think chronologically, if we line the timing up of the father's, I think he filed the motions as fast as humanly possible. Perhaps as a result, not as well drafted, but I absolutely think they contain every single thing this court would need to walk away with an understanding that he didn't consent to the issue being tried at the hearing. The only thing I'm aware of that I think is omitted from the totality of the father's subsequent filings, and Judge Silberman, and this is not to my benefit, but you did mention this, was whether or not counsel requested a continuance at the start of the hearing. I think that's the only thing that's missing here and is not necessary for this court to make the determination that his due process was denied. I wouldn't...
The motion for rehearing, was that resolved without a hearing? Am I recalling that correctly?
I believe there were no further hearings, period, if I remember correctly.
I mean, for my record, we don't have any further transcripts, so I don't know if there were no further hearings or just no further transcribed hearings. Does our record answer that?
I think it does. You might... There are orders without hearing. I'm unaware of any notices of hearing. I know the answer. I'm trying to address whether or not what the record is gonna show you. You have some of the father's last filings being the motions to recuse, which I think extensively address subsequent actions of the court and orders being entered without hearing, and I think that's...
Actually, as I'm looking at the index, it appears the motion for rehearing was July 12th, and the order denying rehearing was July 17th.
And the hearing was July 11th, if I remember correctly.
But that suggests a relatively short time if there was any additional hearing that it could have been conducted in.
Well, I don't believe there... I believe the hearing of July 11th was the last time the parties and a judge ever sat in a courtroom together. And I think the record supports that.
I'll go back to my question. Have you found any authority along the lines of what I suggest may be here, which is no transcript, no indication of what happened at trial? You have a judge making a finding on something that doesn't appear to have been pleaded. Clearly, there's a motion for rehearing. But assuming there's no error on the face of the judgment, can we get to the issue that you're raising?
Oh, absolutely. Absolutely, Judge.
So what's the best authority for that?
Well, I stand on all the cases that I cited that say it's a due process violation, the cases in the brief. Ferris, Vaughn, there's one from another district, because I think I tried to hit every single Williams. Because here's what's notable, and I hate having to do this, but feel like the court's put me in that situation, and this is the best way I know how to answer that. You're asking me if I know of any authority that says it's still due process where there's no transcript. I don't see anywhere in Williams, Vaughn, or Ferris where that trial transcript became critical to the court's determination of due process. To go to...
No, it doesn't become critical to the
Vaughn.
determination of due process. It becomes critical to the determination of trial by consent or waiver.
I don't see how the court, or frankly any arm's length third party, reasonably could pick up the filings in this case and be a complete stranger to it and read all the father's subsequent motions where he used, not the word blindsided, but something substantial, because blindsided is the word that the first district used.
Let me ask one other question. In light of the absence of a transcript, was there any effort under the rules of appellate procedure to present to the trial court the opportunity to render an order saying, here's what happened at the hearing?
No, Judge. But it's also apparent from the face of the record that this trial judge didn't have any business hearing any further proceedings in this particular matter. But there was no effort to try and reconstruct or recreate. The record, thankfully, his subsequent order is so extensive, I continue to maintain this court has absolutely everything it needs to determine that this was not done by consent.
And Mr. Upson, you're at the 15-minute mark if you want to reserve.
Well, based on Vaught and Williams, and more particularly this court's recent decision in Ferris, the due process denial is apparent on the face of this record, and it's dispositive in this case. This court must vacate the order refusing to exercise jurisdiction and remand not just for further proceedings, but before a different judge. Thank you.
Thank you.
May it please the court, my name is Lisa Kirby and I represent the mother, the appellee. We are asking the court to affirm both of the appealed orders, and one of the things I'd like to address first is I believe that there's only 2 orders on appeal. I think there was discussion in the briefs about the motion to recuse being on appeal and the motion for a rehearing being on appeal, the denial of that. I'm sorry, the order on those being on appeal, but I would argue that those are not on appeal today. The only thing are the 2 orders, the one disposing of the case and saying that Florida did not have jurisdiction, and the one the order granting the pickup order, and those are the 2, only the 2 orders on appeal. I really would only like to talk about the pickup order. The pickup order was really an order that put the mother back into where she would have been had because the first pickup order that the father had filed was set aside. So the court gave the father the mechanism to the court gave the father the mechanism to get back into court and argue the facts on the pickup order. He did not do that. I really would just stand on my brief. I don't believe that there's a due process issue. There wasn't a transcript.
And you agree there would be a due process issue if there was no waiver or trial by consent,
Yes,
wouldn't you?
yes.
And so the question that comes up is this record does not on its face show a waiver or a trial by consent.
I think it does.
So the question, okay.
I'm sorry, I didn't mean to interrupt you. I think the order, if you look at the order, the findings in the order, the father came and he showed when he entered into a contract. Why would he have shown a contract that he entered into if they were not trying that issue right then?
We could have objected to it being tried and then did what he could to defend.
He very well could have, but that's not in the record.
I
mean, I don't know.
Did the mother file a response to the motion for rehearing?
No, she did not.
So she didn't herself raise the issue that it was tried by consent because she didn't file any response at all.
But I don't think, I mean, my position would be that she didn't need to. The order that was appealed was the order denying that Florida had jurisdiction. The motion for rehearing, the order on the motion for rehearing was not appealed. And the mother didn't, at that point, Florida no longer had jurisdiction, so she did not have to do anything affirmative in the court. She didn't have to take any affirmative action.
But your argument is that the record, we can glean from the record that it was tried by consent.
Yes, and I think the case law...
She didn't respond to the motion for a hearing arguing that it was tried by consent.
I'm sorry, what?
You correct me if I'm wrong, if I'm go for it, say I'm misunderstanding the record, but the wife did not respond to the motion for a hearing arguing that the issue had been tried by consent.
She didn't respond at all.
Right.
And I don't think in the motion for rehearing, if I'm remembering correctly, he didn't say that it was or wasn't tried by consent. What he said was they were shocked that day, and they were shocked after. All the fact finding in the order, I would say, it supports the idea that there was that it was tried by consent, because a lot of those issues wouldn't have been relevant just for the 6-month issue. Just for a lot of the things that the court found, that testimony wouldn't have been relevant to determine whether they were here 6 months or not.
All that says is that you were successful in getting that evidence before the judge. It doesn't mean that they didn't pound their fists on the table and object to it as being outside the scope of what was in your motion, right?
That's true, but we don't know that. And
that's really your argument here. We don't know.
Well, that's what the case law supports. I think the case law supports that if there is no transcript, you have to only look at the order on appeal and see if there's an error on the face of the order, and there's not. And there is a case where I just don't remember it right now, but there was a case, I think, where there was no transcript, but it was very clear from the motion for rehearing that it was not tried by consent. So the appellate court said, this was not tried by consent. We can see by the motion for rehearing, but that's not the case in their motion for rehearing, and their motion for rehearing is not on appeal.
In that case, was there a transcript of the rehearing, of a rehearing?
Yes, there was a transcript of the rehearing.
I mean, that seems to me to be the distinction. It came out at the hearing that it might have been tried by consent. You said the motion for rehearing, or this motion for rehearing says plainly he was not on notice and he was blindsided. So if we look at the motion for rehearing in a vacuum, it certainly raises the specter, I'm being ambushed at trial.
But it doesn't say that they didn't consent to it.
And your client didn't file a response saying, Judge, you have to deny this because it was tried by consent, or it was waived, or whatever it may be.
Well, my understanding, I was not the trial attorney.
I don't think either of you were trial counsel, if I'm reading the record correctly.
But if it's, my recollection of the rules of civil procedure is a response is not required to a motion. I believe that's correct. I don't know if that's the issue, but I believe that's...
No, the issue I think we're talking about is whether, in absence of a transcript, the face of the record, whether we can glean that it was not tried by consent, or whether, essentially who...
I don't think anything in this record, there's anything in this record that you can glean that it was not tried by consent.
I can phrase that in a way more favorable to the appellant, but I phrase it that way.
Mm-hmm. I would stand on my briefs for the remainder.
Thank you. Mr. Upson?
Thank you. I think I was starting to say when I was talking about arm's length in these motions for rehearing. I think any reasonable person who reads the motions for rehearing is going to come away with one absolute, firm, unwavering conviction that this was not tried by consent. I don't see how both those two, how at the day of the hearing, counsel could have possibly said, that's great, okay, well, we didn't know about it, but let's go ahead and do that then, and still file the motion for rehearing that contains the obvious excitement and outrage that counsel felt in the heat of the moment of showing up for one hearing prepared to prove that she had in fact been here for 6 months.
Honestly, Mr. Upson, all that does is that tells me what counsel's position is on what happened at the hearing, not what actually happened at the hearing, right? I mean, the situation where you have a subsequent transcribed hearing on a motion for rehearing where it comes out and it says, Judge, we've objected, we did not agree to the issue that got tried then, and the court says, yeah, no, I recollect, that indeed did occur, et cetera, et cetera. That's one thing, right? But to simply say, well, because I put a position on a paper and said that I don't, that this surprised me, that necessarily constitutes a substitute for what the law says we're supposed to have, which is transcription of the proceeding. I don't think it does.
Well, but Judge, I think that also unnecessarily starts to shift the burden, because I think it's absolutely uncontested that from day one, the mother's position was, court, you can't exercise jurisdiction because we weren't here for this long. So applying Occam's razor, which seems like the more likely? How could he have possibly known to have shown up for a hearing that was going to be argued on?
So hypothetically, mom's lawyer at the start of the hearing says, Judge, there are 2 reasons why you need to grant us relief. One is they weren't 6 month residents, but even if you find that it was, there's conduct that is unjustifiable on the part of the father, and so you have two ways that you can give us relief. And in theory, the father's attorney says, Judge, we're ready to, or maybe it doesn't even say anything, the trial court says, counsel for the father, are you prepared to move forward? We're ready, Judge. I mean, that would be enough, I think, to support what the judge's ruling was, assuming the facts support, the evidence supported the factual findings and so forth. So that's the problem with the lack of a transcript and the lack of any settlement of what occurred at the hearing.
Well, which the facts don't support, by the way. I have to get back to the fact that the briefs already reflect that there was no we'd have 1,000 pages of transcript and it still wouldn't support the actions that the court took. And I appreciate your point, Judge. And were this a monetary issue, were this a matter involving damages, these are the man's kids. These are parental rights. And I think the court too harshly is imposing too high a burden on counsel in that moment of surprise to say, oh, well, you know what, for months and months and months, the motion said it was going to be about this, and then even if that had happened in an instant at the hearing, counsel had said, well, all right, I guess we'll go ahead and proceed on that. That's simply too high a burden to place on the father, even if that's what actually took place. And again, I maintain from the motions for hearing. And I don't know, I would simply refer to 9110H. I'm admittedly baffled that there's still talk about which orders are subject to review by this court or whether or not it's all the orders subject to review. It's our position that this record contains absolutely everything this court needs to know to conclusively determine that the father was denied due process at that hearing. And again, we ask that you vacate the order that refused to exercise jurisdiction and remand for further proceedings before a different judge.
Very good. Thank you both, counsel. That concludes the oral argument.